I have the same high regard for the Federalist Society that Senator Lee has, but it has failed me in one detail, and that is there's not enough light on this platform for me to read my timeless remarks. But in any event, as Senator Lee anticipated so many of those remarks, I shall shrink what I was going say. But when I was invited to moderate a panel on the original understanding of Congress, I pointed out that I had 0 qualifications to address the subject, but I was assured that the panelists that you see here are all extraordinary experts on that subject and will be able to educate all of us, especially me. But I would observe that during my own existence on this earth, I have seen some rather extraordinary changes in how the Congress does operate. So whatever its original purpose and design, what we can say is that it has wandered far, far, far from whatever the framers of our Constitution had in mind. I personally feel that the greatest cause for the changes I have seen has been the virtual abandonment of something called the First Amendment. Thanks to aggression on the part of Congress and the presidents that have been sanctioned by a compliant Supreme Court, we now have no limits to those matters for which members of Congress feel they are entitled to busy themselves. As a consequence, life in Congress has been transformed into one on an accelerating treadmill, and then it is now revolving at such rapidity that, as Senator Lee pointed out, members simply no longer have the time to legislate responsibly, and as a result, we have an increasing delegation of legislative decision-making to unelected bureaucrats who now write the laws that most directly affect American lives. And again, as he pointed out, these are people who man agencies that simply are no longer subject to any real accountability. So this is a rather dramatic change from, I think, what anyone, even in grammar school, would understand would be the responsibilities of a Congress. But Senator Lee mentioned something else that kind of startled me. When I was in the Senate, and that's 40 years ago, members of the Senate were in Washington 7 days a week, unless there was a specific event in their home states to which they had to attend. I don't know if we had as many months of recess as Senator Lee tells us we have today, but when we were here, we were just overloaded trying to keep up with the mass of legislation. But now it appears that the members of the Senate, along with the House, disappear on Friday mornings and reappear Monday evenings. So there's a lot to be done, and I am looking forward to the enlightenment which the members of our panel will be able to give us. Now, their accomplishments in their careers and the variety of what they've done is spelled out in your programs. So I will simply introduce them with a rather just with a minimum amount of information. The program, after I introduce them, they will make their presentations in series. They will be supposed to speak within 6 or 8 minutes. I don't see any bell that I can ring, but I believe that they are adults and that they are able to to abide by the rules, and after that we will invite them to talk at one another or with one another in a reasonably civilized way, and then also to field some questions. Well, the members of the panel are, in order of their presentations, Professor Tara Hellman, a graduate of the Yale Law School, my law school, who now teaches constitutional law at Syracuse. And then she'll be followed by Professor Akhil Amar, Professor of Constitutional Law at Yale, the school from which I managed to graduate without ever having had a course in constitutional law, which no doubt explains my bias in favor of originalism. Dr. Lou Fisher, a scholar in residence at Constitutional Project, who previously served as the Library of Congress's specialist on the separation of powers, and on occasion as a tutor to this federal judge. And finally, Dr. Gordon Lloyd, recently of Pepperdine, who now serves as the National Advisory Council for the Reagan Presidential Foundation's Annenberg Presidential Learning Center, which he'll explain what all that means. In any event, it's time to begin. Professor Hellman.
Thank you very much for your gracious introduction, and thank you to the Federalist Society for convening this panel. Can you hear me? Yeah. No? I'll try to use my outside voice. I was raised in New York City, where everything is an outside voice. What I'd like to do as the first speaker on this panel is effectively tell the prehistory of the Federal Congress that was constituted in 1789. And in that respect, this is going to be a presentation that's a bit of a tale of two Congresses, but without any of the Dickensian squalor associated with the title. A tale of two Congresses in the sense that in the late 18th century, mid to late 18th century, the notion of a Congress took one of two forms. One was the received conception of a Congress, which was a congregation or a gathering of envoys from different polities in order to discuss their external affairs. And it was in this respect that until, I would argue, 1789, that we see the notion of a Congress being principally used in the American experience. We see this in the form of the Stamp Act Congress, which convened in 1765 and served as the first real notice to the colonies that they could indeed coordinate, that they had much common ground and much in common with one another, indeed more in common than separated them. We see that in the provincial congresses, which were coordinated during the 1770s and served as the precursors to state legislatures. And we also see that, of course, in the two continental congresses that originated during the 1770s, but also ultimately won the war. So we see Congresses initially convened in the in the colonies in the early United States, in the early Republic, in its conventional sense of the term as received in the 18th century, as a way for delegates from different polities to convene in order to discuss their common external concerns. Their internal affairs remained very much a matter for decision back home. But then we see, in the wake of the Revolution, or during the Revolution at the very least, with the Articles of Confederation and Perpetual Union, which I think is a very important part of the title that is too often elided in discussions, a type of Congress being convened in an altogether novel sense of the word, as a standing institution whose purpose is governance. And in theory, that's what the Congress of Confederation was supposed to achieve. In practice, it was really, I think, an early experiment in international organization that didn't go terribly much farther than the congresses convened in the past in the young nation. But then we see the Federal Congress as constituted under Article 1 of the Constitution. And this is an altogether novel, original, singular conception of what a Congress can be. It is, to be sure, a meeting of delegates from different polities, here the sovereign states. But they meet, they convene in the form of a superior government that enjoys a degree of sovereignty that is concurrent with that enjoyed by the polities that constitute this new United States. So, why do I think the Congress of the Confederation is best understood as an international organization? The short answer is, and I think it'll go over well with this audience, because James Madison said so. We're all wearing them, so I'm going to take the liberty of explaining in his words, invoking his own words, on the character of the Confederation government and the Articles of Confederation and Perpetual Union that constituted it. In the debates at on the Federal Convention, he responds to William Patterson's proposal of the New Jersey Plan as follows. We are not to consider the Federal Union as analogous to the social compact of individuals. For if it were so, a majority would have a right to bind the rest, and even to form a new constitution for the whole. That is, we're not devolving into the Lockean state of nature in which we're reconstituting political society as a whole. The Articles of Confederation established a perpetual union, and while the union is non-negotiable, the terms of government under that union are. If we consider the Federal Union as analogous not to the social compacts among individual men, but to the conventions among individual states, what is the doctrine resulting from these conventions? Clearly, according to the expositors of the law of nations, with which Madison had extensive familiarity, that a breach of any one article by any one party leaves all the other parties at liberty to consider the whole convention as dissolved, unless they choose rather to compel the delinquent party to repair the breach. In some treaties, and here he is treating the Articles of Confederation as a treaty, indeed it is expressly stipulated that a violation of particular articles shall not have this consequence, and even that particular article shall remain in force during the war. But are there any exceptions of this sort to the Articles of Confederation? So far from it that there is not even an express stipulation that force shall be used to compel an offending member of the Union to discharge its duty. And many offending members there were. States were attempting to enter secret compacts with other states. States were making diplomatic overtures to foreign nations. States were refusing to comply with the requisitions of the Congress of the Confederation. It's a problem of international organization. So what distinguishes the government constituted in 1789 from the one constituted under the Articles of Confederation? Well, the government constituted in 1789 is no longer a confederation. It's now a Confederate Republic. And the great bastion of that republic, of the center of political power, and the center of political representation in that public is the Federal Congress itself. The Federal Congress combines all the internal advantages of a republic with the external force of a monarchy. The states enjoy a measure of sovereignty over their internal affairs, but they also participate in national affairs through Congress, which is what makes the Confederate Republic truly republican in character. Here, the states are directly represented in the Senate. They're proportionately represented in the House, and this captures what Madison describes as the genius, the respective genius of the House as opposed to the Senate, the forms of representation. Now, I will conclude, even though we have much more to say, by tying this to a remark made by Senator Lee. and that is that the framers didn't anticipate a full-time Congress. Far from it. They didn't anticipate career politicians at all. They anticipated that the members of Congress would be citizens who were, in their words, called away from their daily pursuits to serve the public good. But in serving the public good, they would enjoy a number of powers, chief among which was the power of the purse, and their coordinate powers as a check upon the executive. I'll leave it, though, to my co-panelists in order to address those aspects of the Congress further. Thank you.
Professor Amar.
It's an honor to be here. Thank you so much for this very kind invitation. It's always a great privilege. So we're here to talk about the first Congress. That was a wonderful setup. Let me begin with a quote. Quote, "Congress shall make no law." I like to stop there because it gives you a thrill. But it does go on, you see. "Respecting an establishment of religion or prohibiting the free exercise thereof, speech, press, petition, assembly." Okay. Limiting Congress. Who does that? The first Congress itself limits Congress, and therein hangs a tale. It's a very interesting idea that this Bill of Rights that begins with the words "Congress shall make no law" and ends with the 10th Amendment and has a Second Amendment that's about state militias in part and local juries, very much featuring local institutions. A First Amendment that actually not only doesn't apply originally to the states, but protects state institutions. Congress shall make no law respecting an establishment of religion, which means Congress can't disestablish the existing state churches that do exist in a bunch of states. That set of huge precepts in our system limiting Congress comes from the first Congress. So what's up with that? That's very interesting. Well, one thing that's up with that we should remember is that in important respects, even though the ratification of the Constitution was an up-down affair, each state ratifying convention basically could say yay or nay, the plan that emerged from Philadelphia was in important respects renegotiated in these ratifying conventions, and a lot of the yes votes were yes, but. Yes, we'll vote for this, but we expect actually some modifications, and it was up to the first Congress to do that or else. And or else they're not going to get reelected. So since Madison was invoked, he doesn't propose a Bill of Rights at Philadelphia. He originally says it's a bad idea. The Federalists actually say, you know, 3 inconsistent things about a Bill of Rights. They say, well, you know, it's unnecessary. In fact, it's dangerous. And oh, by the way, we have one called Article 1, Section 9. I don't own a dog. It didn't bite you. You kicked it first. And these arguments aren't so good, and Americans immediately see, for first day of the ratifying conventions, they say, dudes, you forgot the rights. The Constitution is crowdsourced, because state constitutions have bills of rights, you see, and ordinary people think they're entitled to them. And so Madison flips. He has to flip because he wants to get elected to the first Congress. So he says, oh, well, when I'm in the first Congress, I'll propose a Bill of Rights, and he does do that. And if he doesn't, he won't get reelected. And here's another point. So they knew they had to do this first Congress, and here's another point. They actually weren't just limiting themselves, they were limiting their successors because they weren't expecting to be there forever. Only 20% of the members of the first Congress were in Congress 10 years later. And even those 20% had not all served continuously. So it is a different world. People didn't want to be away from their families that long. You can't jet back and forth with red weeks and blue weeks back then. Okay, so, and since we all revere the Bill of Rights, we should remember it comes from the first Congress. I would want you to remember that much of what we call the Bill of Rights, though, isn't really the Bill of Rights. Think of the big Bill of Rights cases that pop into your head when I say, think about important cases about liberty and equality in America, and you will think, whether you agree with them or not, you'll think of Gideon versus Wainwright, and Brown versus Board of Education, and Miranda versus Arizona, and Lawrence versus Texas, and New York Times versus Sullivan, and on, and none of those is a Bill of Rights case. because the Bill of Rights begins, Congress shall make no law. And every single one of those cases and a gazillion others involve states and localities. That's the 14th Amendment. That also comes from Congress. You see, Madison wanted, actually his original Bill of Rights, to limit states. It passes the first house as the original 14th Amendment. He doesn't pass the Senate, but eventually that becomes our second Bill of Rights, our second founding, and it comes from Congress itself, and it's going to end with different words. Congress shall have power in the 13th Amendment, Section 2. Congress shall have power, 14th Amendment, Section 5. Congress shall have power, 15th Amendment, Section 2, as distinct from Congress shall make no law of a certain sort. Okay, so now how about other things that that first Congress does? It establishes some important ideas about congressional size. The two biggest anti-federalist objections to the original Constitution as it emerged from Philadelphia are you don't have a Bill of Rights and the Congress is too small to be genuinely representative and trustworthy. The original amendments that emerged from the first Congress were 12 in number, and the first one was about congressional size and said Congress has to be bigger, and the first Congress actually makes it bigger, thereby mooting in some ways the need for that original First Amendment, and that's because once there's a census, they immediately increase. The original Congress is 65 persons. Only 2 states have state legislatures that are that small. There are 1,500 state legislators across the country when you add them all up in lower houses compared to 65 in Congress. So it's just seen as too small to be genuinely representative, and so they do that post-haste. They actually increase the size to about 100 after the first census that they organized. And speaking of size, they build a humongous building. Okay, and this is, you know, if you want to think about, well, have they really violated the original understanding? You just see the boulevards in this town, or that L'Enfant built, and the size of that building. You compare it to, say, Independence Hall, which is one of the 2 biggest buildings in the continent before that, and there are about 100 Independence Halls that you could fit into that congressional footprint, even as originally designed. They're building it on a monumental scale. The only thing remotely like it, since Senator Lee is here, is Salt Lake City, you know, which is built on this monumental scale as the third Rome. So I'm not so sure that they weren't actually anticipating the Leviathan that would eventually emerge when the system fills in its use. Okay, here's another thing the first Congress does. It organizes itself with all sorts of rules about how it's going to operate. Here's one important thing. It doesn't have a filibuster. And in fact, there's no important filibuster of any significance throughout the antebellum period. I'm here in the presence, we're all here in the presence of one of the greatest scholars of Congress in existence. One is, you know, I have several on this panel, but my friend David Mayhew is back there. And David Mayhew actually wrote a piece. I can give you the site. Actually, it's on supermajority rule in the United States Senate. It's in volume 36, page 31 of the journal Political Science and Politics, supermajority rule in the U.S. Senate. There's no important filibuster early on. Here's how I can prove it. If there is, name the bill. Name the important bill before Abraham Lincoln that's filibustered to death by a minority, because I can't think of one. Or put differently, in 1850, that compromise was a really big deal. You know, Joe Biden might say a big effing deal. Because it gives the free states, ever so slightly, with the admission of California, a slim majority over the slave states, but a slim majority would not be important if majorities didn't rule at the end of the day in the Senate, which they did. Minorities got to speak, and at the end of the day, majorities got to vote. And so Congress organizes itself. Now, Congress also does a whole bunch of things that gloss our Constitution. Let me just end with just a few quick things that first Congress does, because they're pretty significant. They assert a power, for example, of oversight. Where does that appear in the Constitution? That they can hold hearings and hold people in contempt and even imprison them in the House and Senate if they misbehave. Doesn't say that in the written Constitution, but from day one they do that. They pass all sorts of laws about how they will react, how they will interact with the presidency. the decision of 1789. The Constitution doesn't say what happens about who, it talks about who can appoint officers, but not who can fire them, disappoint them. And if you read the Federalist 77, Federalist 77 says, oh, the Senate's going to be involved in firing of people, but that's not what happens. And that's because of the first Congress passing this important statute, decision of 1789, that says cabinet officers serve at the president's pleasure. And senators are not involved in a kind of legislative veto in dismissals. In foreign affairs, the first Congress validates all sorts of things that presidents unilaterally do. They send ambassadors, secret envoys without consulting with the Senate, and Congress eventually authorizes all of this and approves it in negotiations with England and elsewhere. So just by way of conclusion, where does it say that Richard Nixon can send secret envoys to China, Henry Kissinger or Barack Obama can send secret envoys to Iran, which he did? Well, George Washington sent a secret envoy, Gouverneur Morris. And where does it say that you don't need the Senate pre-approval for all the terms that you're going to negotiate with the treaty? Well, the Constitution doesn't say all of that, but the first Congress in consultation with George Washington establishes a whole bunch of very important precedents defining the boundary between the executive and the legislative branch. Okay, that's enough for now. Thank you.
And before Dr. Fisher starts, I need to confess encroaching senility. And when I spoke about the First Amendment being ignored in my introductory remarks, I obviously meant the 10th, although the First Amendment does seem to be under attack these days. But in any event, I do know the difference, even though I didn't have a course in constitutional law. Dr. Fisher.
Okay, good morning. Happy to be here with my colleagues and with Judge Buckley. I enjoyed very much when he was in the D.C. Circuit, meeting with him and sharing a lot of ideas. When we talk about Congress, we have to talk about self-government. And those who hate Congress and would like to weaken it, you're weakening self-government, and we'd have no reason to call ourselves a democracy here. We'd have 2 elected people in the executive branch and no elected people in the judiciary. And it's interesting, this morning it was mentioned that Congress is unpopular. Yes, I think it has always been unpopular. And when I read articles about the unpopularity of Congress, a lot of it has to do with the public watching Congress in committee and on the floor, and what they see and they don't like. They see deliberation, they see amendments, they see disagreement, and that turns off people toward Congress. Well, that's what a legislative body is. And we would see all those things if we had a closer look at what goes on in the executive branch and the Situation Room and what happens in the conference room of the Supreme Court. So Congress is public and will always be unpopular. That's the nature of it. And there's another difference between the 3 branches. We do tend, particularly after World War II, to idealize the president. He's for the national interest, whatever that is. He's for the national interest, and Congress is for the local interest. So that's a bad thing. We idealize the Supreme Court. They are somehow masterful in understanding the meaning of the Constitution. You'd be hard-pressed over the last 2 centuries to back that up with any evidence. In Congress, we don't idealize Congress. We take it as it is. So that's the way it is with Congress. But anytime you want to weaken Congress and make fun of it, you're giving up any possibility of a democracy and self-government. The framers were for self-government. And interestingly, they had a lot of experience in self-government in colonial times. There's a limit to what London could do in the colonies, and you had to figure out a lot of things right here, getting to meetings and talking with each other, finding some common ground, learning about rules. So we learned about self-government here. In the early 1990s, I went with the American Bar Association to Eastern Europe to help countries that had broken free from the Soviet Union, and we were told that people in those countries lacked civic culture. And we didn't know what that was. And they said, we lack civic culture. We've never had any self-government. We've always had somebody, either the church or the Communist Party or Russia, tell us what to do. We have no experience. The framers did. Framers had plenty of experience. And the framers chose to have self-government with Congress with the lead role. So let's look at what has happened. First of all, this notion of judicial finality, that when the Supreme Court says something about the Constitution, that's final unless the justices change their mind or unless you amend the Constitution. And in fact, that's never, ever been the case. But you have people who write in the New York Times and the Washington Post, and you hear them on radio, and they say precisely that. When the court decides something, that's it, with those two exceptions. I don't think there's any evidence at all that the framers ever believed that when the Supreme Court decided a constitutional question, it was final. And where do we get it from? And it's cited in recent decades by the Supreme Court, that one sentence from Marbury versus Madison. And I'll repeat it to you. You all know what it is. And you look at that sentence and see if you can find in it anything about judicial finality. And here's the sentence. It is emphatically the province and duty of the judicial department to say what the law is. Well, it's a popular sentence, but that'd be emphatically the province. So if you get rid of the frills up front and say it's the duty of the judicial department to say what the law is, well, how about making it more direct? It's the duty of courts to decide law. But that's why we have courts. We all know that. There's nothing in there about judicial finality, nothing in there. I can change that sentence slightly and see if you think this is true. I hope you say it is true. It is emphatically the province and duty of the legislative department to say what the law is, right? But we don't believe in congressional finality either. So this is a cornball thing that has been made popular, not just in newspapers, but in law reviews and political science magazines. And that's the way it's taught in law schools. It's the easy way to teach it. Just look at the Supreme Court decisions. Don't worry about what Congress and the executive branch are doing. It's an odd thing that we look at Marbury versus Madison because the court had no jurisdiction, right? That's what Marbury versus Madison is. We have no jurisdiction, that you cannot come here directly. You have to start down below and then maybe a appellate case. So if you have no jurisdiction, how can you make any kind of declaration in the case? No jurisdiction. And actually, Marshall admitted that in 1821 in Cohen's against Virginia. We had no jurisdiction. Everything after that is dicta. We all know that dicta, the sole organ doctrine was dicta, finally corrected this year after 79 years from Curtis Wright. So we all governed by erroneous dicta and erroneous rulings. Marshall understood, actually John Marshall in McCulloch case, he suggested on the U.S. Bank case that this is for judicial court alone, and he upheld it. Now, there's nothing final about that. Congress would have to reauthorize it at any time, and if it didn't want to reauthorize it, that was the final word. The court would have no role. If you did reauthorize it, and it comes to Andrew Jackson, he vetoed it, and that's the last word, unless you could override, which they could not. So all three branches made constitutional law. How about presidential power? The framers knew all about the prerogative from John Locke, that the president, the executive branch, would have total control over external affairs. That's what John Locke believed, and he had the Lockean prerogative. William Blackstone in the 1760s, 1770s, he gave all of external affairs to the king, everything. Well, the framers rejected that. Nevertheless, in this Curtis Wright case in 1936, Justice Sutherland, with dicta, said that the president's control over external affairs is plenary in nature. All you have to do is read Article 1 to show that that's false. But we lived with that, and we're still living with it with the Zivotofsky case in June. We never got rid of that false doctrine by the Supreme Court. It's still alive. But we still, I think from 1950 on to the present time, we do have this notion that the president has authority to go to war on his own without ever coming to Congress, starting with Truman and continuing with Clinton, who never came to Congress one time for military activities, continuing with Obama, who went to war against Libya in 2011, never came to Congress, goes to Security Council as though that's a substitute. It's not a substitute for Congress. So we've had unconstitutional wars from 1950 to the present time. And it's the fault of Congress. It's been abdicating. I wrote a book. One of my books is Congressional Abdication on War and Spending, the two prime prerogatives of Congress, abdicating. So let me finish with what the framers expected from the start. And I think a lot of it has to do with John Jay writing in Federalist number 4. You would think if anyone is favorable to executive authority in foreign affairs, it would be John Jay. He was expert in that field. But in number 4, he says we have looked at other countries, how they go to war, single executives making that decision. And we should never do that here, because what we have seen when single executives go to war on their own are catastrophes for the country and lives lost and fortune squandered. And then I think, this last thought here, a lot of people say, oh, the framers, that's 18th century, how can you look to them for guidance for the 21st century? Well, what the framers looked at was not history, was human nature. And I think what John Jay said in Federalist number 4 is even more true today. I think we've seen the damage done when single executives go to war without legislative authority. Thanks very much.
Dr. Lloyd?
Well, one of the advantages of sitting here is that you can ring a bell. You can juke me, as my Caribbean ancestor Hamilton would point out. You could always juke me instead of ringing the bell, man. Just juke me. All right. One of the difficulties and advantages of going last is that everything may have been said before, but then you get your lines that you want. And I think that one of the important comments that have come through from all three speakers is the importance of opinion. Like Professor Amar is talking about what the first Congress did, and that becomes part of an opinion about the nature of the institutions and what Congress is supposed to do and the nature of separation of powers. And it becomes very, very difficult after that to simply reverse opinion. Marbury versus Madison as an opinion gets into the body of the politic, and then it becomes very difficult to alter it because it then gets passed down to generations and time bestows a certain dignity on it. Truman, 1948. So I think one of, and I hope we get to talk about that, because the senator this morning was, I think, partly optimistic and partly pessimistic and calling for a fundamental change in opinion and thinking that it was on the move. So I would like us to talk about changing opinion, non-changing opinion, sort of the oppressiveness of opinion in the sense that it curtails innovation, but at the same time, the dignity that opinion gives simply to institutions. Professor Fisher talked about the New York Times and the Wall Street Journal and about the idea of the Constitution. We live under a Constitution, but the Constitution is what the court says it is, basically. And I would say that without stretching the interpretation too far, that would be what we would call a progressive or activist interpretation coming from those two newspapers. So you gave me a line, see? And the line, it comes from yesterday's Wall Street Journal op-ed. President Obama has rewritten law after law and dared Congress and the courts to stop him. Right? So therein lies the problem, sort of executive overstepping. and dared Congress and the courts to stop him. Next line. The justices should take up the dare to protect the Constitution. What is missing? How about the Congress taking up the dare to protect the Constitution? So even the Wall Street Journal, not just the New York Times and the Washington Post, fall into this notion that the Constitution belongs to the court. And I think we need to change that if you want to revitalize Congress. And I'm not talking about impeaching the judges. I'm talking about rereading the Constitution and understanding what are the powers of Congress. What about the presidency? Once we adopt the language of war, it seems to me that we've lost the idea of deliberation, because you don't deliberate with enemies. It's friends and enemies, and it's about winning and losing. It's not about deliberating and compromising. And if you have not just war powers with regard to overseas, but you have war powers at home. For example, New Deal. Give me the powers to fight a war at home equivalent to the First World War. A war on poverty. A war on dumb children. No dumb child left behind. A war on fat people. A war, once you initiate war, then the executive power is going to grow. And the federal executive is going to grow at the expense of Congress. So I think two basic things that we have to reconsider are, first of all, the language which we use in understanding politics. Is the language one of getting things done, solving problems, war, or is it deliberation? And the second point is, how does opinion get into the body of the politic, and how do you change opinion? What I want to also emphasize with regard to the original Congress is that there were many plans. And so, in a way, no one got what they completely wanted, so that we get a more perfect Congress rather than a perfect Congress. And I think if we keep that in mind, we will be trying to reform a Congress in the future which is consistent with consent of the governed and deliberation. It is virtually impossible, I think, to get a perfect Congress. Well, what would a more perfect Congress be back in 1787? Something different and better than the British Parliament. Something better and different than the Articles of Confederation. Something better and different than the state legislatures. There's the Virginia plan, as we heard. There's the New Jersey plan. There's a Hamilton plan. None of those plans made it completely into the final Congress. One of the most important parts of the final plan comes out of the Committee on Detail and then goes into the Committee on Style, and that is the listing of powers. The Virginia plan has no listing of powers. Congress can do all those things for which the states are incompetent. The Articles of Confederation, as we heard, lists specifically the powers that Congress can do, can exercise. So now we have this middle ground where Congress can engage in 18 powers. So you're listing, but are you listing? And that becomes part of the problem of interpretation. But I think the idea is to create a Congress which is better, which requires us to understand what the problem is. What's wrong with the others? We can talk about that. I think the second thing we need to keep in mind in terms of a more perfect Congress, relative to what else, is that this Congress is to be part of a more perfect republic. Not a perfect republic, that's Plato. That's impossible. It's probably unlivable, and it doesn't have any liberty. And it's not Montesquieu's republic because it's too small and homogeneous. So we're looking for a different republic. something along the lines, say, of Adam Smith, who would argue that the wealth of a nation depends upon the productivity of labor, which depends upon the division of labor, which depends on the extent of the market. And I think Madison's point would be the health of a nation depends upon the control of faction, and the control of faction depends on the division of interests, and the division of interests depend on the extent of the orbit. And so there's this parallel to create an extensive republic. In fact, something like six of the 18 powers that are listed are powers of commerce. So the role of government is linked to commerce, the original intent. 9 of the powers are associated with defense. So there are 2 basic original understandings of what it is legitimate for a Congress to do: encourage and support commerce, but not monopolies, and encourage interstate commerce and international commerce, and defense. So there are war powers that the Congress has, and et cetera, et cetera. And I think the third issue that helps us understand the original Congress, in addition to creating it more perfect than what went before, and a different kind of republic than what went before, and Congress is at the heart of that republic. Not the judiciary, not the executive, but Congress is at the heart of that republic, a deliberative republic. The third one is this very, very tricky phrase, which we've been pointed out, Article 1, Section 1, where it says, all powers herein granted. The executive and the judiciary do not start off with all powers herein granted. Some of our conservative friends have interpreted that to say that there are other legislative powers somewhere in the Constitution, and usually it is located in the presidency. Therefore, giving the president legislative powers, and therefore, how can you possibly stop the president from legislating and making laws if those legislative powers, not herein granted, are granted to the president? Well, I suggest that that phrase, all powers herein granted, is an attempt, is the predecessor for the 10th Amendment. It is directed to the relationship between Congress and the states, not the Congress and the president. And to interpret all powers herein granted as a limitation on Congress and a grant of legislative power to the executive is to give the whole battle away. That is a federalism question, or what we might call the vertical question. And my proof of that is that this comes out, this phrase enters with the Committee on Style report a week before the end of the convention, when people were concerned about what do we mean by necessary and proper? What do we mean by interstate commerce? What do we mean by general welfare? What do we mean by this? Isn't this a hole that you can drive anything through? And part of the response is, no. Congress only has those powers which are herein granted. And the debate continues, and that's when, to anticipate or to follow Professor Amar, that's when Mason and Jerry and Randolph introduce a Bill of Rights to restrain the Congress. I think his point is extremely well taken. The Bill of Rights is not a restraint against the executive. It's not a restraint against the judiciary. It's a restraint against Congress on behalf of the people and the states. So therefore, Congress is supposed to be the most dangerous branch. And so I think, to conclude, the task the framers faced was, how do we have Congress being the most important branch, but be decent? How do we help the president and the judiciary bring a certain degree of constitutionalism without taking over? But if you let the judges get into the Constitution, they'll take over, says Brutus. Hamilton, it'll never happen. Congress won't let it happen. What about if the president becomes the imperial presidency and becomes the king? The president is weaker than the governor of New York, says Hamilton. Moreover, Congress will never let it happen. Well, I think our task now is to is to encourage Congress to realize that ultimately it is boss. In a democratic republic, it is boss. And just to draw that line without feeling as if you have to be somehow weird to suggest that, you have to go run to, interesting, this morning. Well, what can we do? Does Congress have standing in court? Who cares? Why is it that the Constitution is owned by the court? For example, the Constitution ultimately is owned by 2/3 of the House, 2/3 of the Senate, and 3/4 of the state legislatures or the people. The president and the courts are not involved in the amendment process.
Dr. Lloyd has thrown out a couple of challenges that the other panelists may want to address. One is how do we achieve fundamental changes in opinion? How do we bring about reform of Congress and the Enlightenment?
Yeah, let me comment on this notion that Congress is restricted to hear and granted. That would mean Congress couldn't investigate. It's not hear and granted. It couldn't issue subpoenas. It couldn't do all sorts of things. And when the Supreme Court says this is a government of enumerated powers, you'd have to ask justices, where did you get the power of judicial review? It's not enumerated. So the framers never limited government to enumerated powers. We've always had enumerated and implied powers that could be reasonably drawn from enumerated powers. That's always been. There is, I think, unfortunately, confusion today that the president has inherent powers. And people say, well, that's the same as implied. Well, it happens in not just two different words, but two different meanings. Inherent means that if it inheres in the president, no one can check it. And that's the meaning from the three presidents on 4 occasions who claimed to have inherent powers. That's Truman with the steel seizure case, talked about inherent powers in district court, lost badly in district court. By the time it got to the Supreme Court, Philip Perlman, the Solicitor General, didn't use the word inherent one time. Nixon claimed to have inherent power not to spend appropriated money, the impoundment crisis. He lost in court and in Congress. Nixon claimed he had inherent power to do, without a warrant, domestic surveillance. He lost in Congress. He lost in court. And George W. Bush said he had inherent powers to create military tribunals. He lost in Congress and in court. So inherent power, you're not talking about the Constitution anymore.
On public opinion, which is, I think, a very useful and important concept, it's worth remembering that the first Congress decides in the House to make its deliberations public from day one. That's not required by the text of the Constitution. That wasn't the completely uniform practice in Parliament. It wasn't true of Congress under the Articles of Confederation. The Senate joins in the act about 6 years later and makes its deliberations in general public, and these are important elements of an unwritten constitution. They gloss, I think, the original understanding, just in the same way that the power of each house to have oversight hearings and subpoena power are early glosses. One of the reasons you want a big building is so that the rest of us can actually observe, even pre-C-SPAN. It's for the gallery and not just the lawmakers. One of the things that the first Congress does from the beginning is this deliberation and argumentation, and we, the people, can actually see not just what they're saying, but how they go about arguing, and they're trying to implement the Constitution, so there's lots of constitutional argumentation in the first Congress, and so you can see moves of text and what the people understood when they ratified original intent, so to speak. You can see moves from structure in that first Congress. It's a wonderful, actually, laboratory to see constitutional discourse, constitutional argumentation. If you want to see it well done, read the late, great David Curry's book on the first Congress in this respect, because he combs the records and actually gives you wonderful exemplars. I mentioned the decision of 1789 about Congress by statute deciding and arguing about what the president's powers of removal are going to be or not, and what, if any, role the Senate and the Congress should play in all that. They do the same thing with the judiciary. They set up the judiciary, of course, very famously with the Judiciary Act of 1789, specifying how many justices there are going to be. It's 6, an even number, how odd. That's a joke. This is kind of like Hammer versus Dagenhart. Because they're not expecting the Supreme Court to be this big deal. If they're going to decide everything, then you'd want an odd number so there'd be a clear majority for things, and they're not quite anticipating that. They're anticipating a more modest judiciary. How many lower courts, all set up by Congress. But also in Section 25 of that Judiciary Act, I think very much in contemplation, very expressly, of a certain kind of judicial review, perhaps not the judicial supremacy that some people think today, but you'll see a very rich set of constitutional arguments about the role of the judiciary, for example, in the first Congress, in that. And the early justices, the great ones, are themselves former congressmen. John Marshall is a former congressman. Joseph Story is a former congressman. Congress is, in a whole bunch of ways, I think, in the original intendment, a kind of first among equals branch, first in the text, first in size. It structures, since the necessary and proper clause was alluded to, there's a federalism dimension of that. Congress has power vis-a-vis states, but also Congress has power horizontally vis-a-vis other branches. The necessary and proper clause gives Congress power to organize the executive branch, how many cabinet officers there are going to be and so on, what the division line is going to be, and the judiciary. So you really do see a lot of that, and that is connected to public opinion because the public is watching, because there are open galleries in the House from day one.
As to the issue of public opinion, I think the shortest way, but perhaps also the most provocative way to address it is from 2 angles. One, the less provocative angle, is that at the time of the framing, there were no political parties. There were political factions, but organized political parties were a subsequent invention, and that alters the nature of congressional politics dramatically, and the way that the way that public opinion is formed and galvanized to bring about political change. Bringing us to the present day, though, and this I think is probably the more provocative observation, it's that the terms of public discourse have changed many thousands of times over in the last 5 years, much less the last 250 years. When you think about the role of public opinion in the framing of the Constitution itself, much less its implementation, the Constitution was ratified through public opinion. The Federalist Papers were an attempt to engage public opinion. How would one compose Federalist Papers through one of the most basic modes of public opinion today, which is the meme, right? What would a Federalist Papers meme look like? Would it be plastered over in Kardashians and lolcats? Well, my point here is not to trivialize the issue, but to underscore the way that public discourse has changed and the need not for our leaders to dumb down discourse by any means, but to recognize the need to engage meaningfully in that way. It's an if you build it, they will come approach. If you make the ideas available to the public in a way that feels compelling and salient to their lives, then they will come to those ideas. I think that's part of the enterprise we engage in as members of the Federalist Society, but I also think it's a very useful proposition for members of Congress to think about.
Let me just add one other point here, talking about the language and how language changes and perceptions of change. For example, neither in the Constitution nor in original opinion did we talk about midterm and off-year elections. What's off about it? Well, and what's mid about it? It's as if the presidential election is the only show in town. That was not at the beginning. And I think there have been a number of turning points, and part of the American narrative, part of it is, when did America go off the tracks? when did America go wrong? And it's as if this generation is facing the crisis and the previous generations had a homogeneous existence. And so that I would like us, when we're thinking about the reform of Congress or what is the shape of Congress, is to remember that filibuster, changing the filibuster, giving an item veto, doing such and such, are peripheral to the big question. And the big question is, do we want deliberative democracy, or do we want plebiscitary democracy? If we want plebiscitary democracy, you've got the president, plus the administrative state with experts. To what extent can we govern ourselves? I don't want us to lose those big questions, because if those big questions aren't important, then we are wasting our time in the sense of just fiddling around. Because those are the big, I think, the important questions. And I'll stop there.
Very good point. We have these constitutional archaeologists on board. I'd like to ask a particular question. We do know one change that occurred since the Constitution was adopted, namely the 17th Amendment, which provided for the popular election of senators. I'm curious to know what, if any, impact that change has had in how we now govern ourselves. Does anyone have a point of view on that?
It's affected every element of our system. I earlier commended to you the work of David Mayhew, and I mentioned David Curry's work, so here I can't forbear from saying I think that the best piece on this is an article entitled Indirect Effects of Direct Election. It's in the Vanderbilt Law Review. It's written by Vikram Amar, not my son, he's only 17. Only Mike Paulson's son writes stuff, but my brother, who's dean of the University of Illinois College of Law. So, before the 17th Amendment, it changes the nature of the House of Representatives. You used to have mere House members who could get themselves elected president, people like James Madison, Abraham Lincoln, none of them after the 17th Amendment, because now the Senate can claim to be every bit as populist as the House and actually more distinguished in some ways. It changes the nature of American federalism, of course, in so many ways. It paves the way for unfunded mandates and a New Deal and a great society, because state legislatures no longer control the upper house, and so the upper house feels more free to impose all sorts of stuff on state governments. It changes, as I already mentioned, the nature of the presidency. Even we have lots and lots of the Senate has always been a nursery of presidents, you know, and the definition, a senator looks in a mirror and sees a future president. We've always known that, but even more so after the 17th Amendment, it's actually, in recent history, sort of been governors versus senators, more so than before even the 17th Amendment. You had governors, actually, in the period right before the 17th Amendment, and now more senators. It's changed the cabinet. You used to have things called cabinet sandwiches. Here's how it worked. You'd leave the Senate to be a cabinet officer, because you could help your state, actually, in various ways as a member of the cabinet, and they'd hold your seat for you. The state legislature would explicitly or implicitly say, when you're done with your service in the cabinet, we will give you your seat back. You can cut that deal with the state legislature. You can't cut that deal actually with the citizenry of a state. So we had many, many cabinet sandwiches from the Senate to the cabinet, back to the Senate before the 17th Amendment. We've had none since. We've had cabinet officers join the Senate, but then they never go back. Hillary Clinton or Lloyd Benson, Salazar, many, many, John Kerry. They're not going back to the Senate because you can't cut that deal with the electorate. So the 17th Amendment has had transformative implications for our system.
Yeah, well, I agree 99% with Professor Amar. There are a couple of issues that I want to quickly raise. First of all, there was nothing, shall we say, principled, I think, in the beginning about the state legislatures electing the Senate. It was part of the conversation that Sherman insisted in bringing the states into the structure. There's not part of the Virginia plan. So it is part of this conversation rather than say, this is not contradicting Professor Amar. It's sort of trying to show that it had now, although it started off as a sort of a compromise, it became part of opinion. And so its loss changes things, even though it may not, even though the Senate may have been constructed on other principles if you follow the Virginia plan. I would add that for Sherman, who was instrumental in getting the state legislatures to elect the Senate very early on, the more important point for him was equal representation for the states in the Senate. As important or more important. My proof is, if you take a look at Article 5, the only thing virtually that cannot be amended in the Constitution is that no state can be required to give up its equal representation without its own consent. So that, I think, is the key to the power of the states in the Senate as far as the original author, Sherman, intended. Now, it may turn out through opinion and practice that the state legislatures electing became more important in practice. Thus, it had a greater impact. And that's where I totally agree with Professor Amar. Last point, one of the fascinating things for me is that the 17th Amendment was passed by 2/3 of the House, 2/3 of the Senate that have been elected by state legislatures, and ratified by 3/4 of the state legislatures. Why the heck would they do that to themselves? So that this becomes a quandary for me. Was it committing sort of, I mean, what was opinion in the land so broad that state legislatures were willing constitutionally to give it up? It wasn't some kind of coup. You can't get much more than 2/3, 2/3, and 3/4, but they did it.
Judge? Just a comment on the 17th Amendment. I think the problem of the Senate goes far beyond that, and the senators love to say we're the greatest deliberative body in the world. And the pattern, however, is for the House of Representatives, as criticized as it is, to pass appropriation bills, pass other bills, and they go to the Senate, and there's no action. Nothing happens in the Senate on a lot of legislation, important legislation. So I think the Senate, instead of this great pride they have in their institution, should say they're not doing their job, and they're not actually around enough in town to do their own work. So there are a lot of important groups in town trying to invigorate Congress, and lots can be done. I mean, filling the amendment tree, the difficulty in the Senate of having amendments today, having any kind of debate.
Very briefly, ditto. And I would also add that from the original view of Congress, what the 17th Amendment does is alter the character of the senator himself or herself within Congress. Because under the original conception of the senator would, unlike a member of the House, be able to pursue a longer-term path in government and acquire experience which the framers viewed as possessing an oracular power above anything one might read in a book, that would serve them in the many different obligations that a senator must discharge under the Constitution. That goes to the role of the senator in confirmations. That goes to the role of the senator in exercising the national treaty power. And that goes to the senator's lawmaking function. In the Federalist Papers, the assumption is that the senator will have a greater degree of expertise and personal breadth than members of the House by nature of the function of the Senate.
I'm sure that members of the Congress, rather of this the audience, have some questions that they'd like to pose to our panelists. I assume there's some microphones that can be passed around.
Thank you, Judge. Two questions. Two powers of Congress that have not been much used: power of impeachment and a power of limitation of the jurisdiction of the courts. Should those be used more broadly, and why hasn't Congress considered using them more broadly?
Any comments?
Well, one thing that Tara mentioned that I think is very important is the development of political parties. Political parties are literally, since I mentioned the size of the congressional building, and it's you know, it's pretty darn big for those of us from out of town. I could mention parties are literally built into the architecture of the chambers, with an aisle, with folks on one party on one side of an aisle and folks on another party on the other side of an aisle. So now what does that mean? That means when you add the Constitution's requirement that takes a 2/3 vote to convict in impeachment, and a two-party system in which rarely has one party had 2/3 or more control of the Senate, you're not going to, impeachment is actually not going to be a particularly powerful device. This was proved early on, not in the first Congress, but early on in the Jefferson administration with the attempted, there was an impeachment of Justice Chase, but it did not achieve the requisite 2/3 in the Senate. The presiding, Justice Chase was a justice on the Supreme Court. He was thought to be too partisan in various ways. The presiding officer was none other in the Senate than Aaron Burr, then under indictment for murder. And the wags said, in most countries it's the murderer who's arraigned before the judge, but here we have the judge arraigned before the murderer. But that early failed impeachment, more than a majority voted to convict, but not 2/3, rendered impeachment in Thomas Jefferson's phrase a mere scarecrow. And so again, we go back sort of early on, and I think Tara's point about the development of the two-party system as competition heated up between Adams and Jefferson in 1796 and 1800 is a very important part of our story.
And let me say something about impeachment. It is a tool, and I think it can be used and should be used. One of the problems is what the Senate did to the impeachment process after the House impeaches and goes to the Senate for trial. Up to 1936, the Senate used to take 2 votes. And the first vote would be guilty or not. And if it's not guilty, that's the end of it. But if from the first vote guilty, then you have to go to the second vote, remove or not. And someone in 1936 said, well, if they're guilty, they should be removed. There should be 1 vote. So the result of this is that in the Clinton impeachment, after it went to the Senate, on the 2 votes, on perjury and obstruction of justice, there was not the supermajority to find him guilty. But the odd thing is that although a lot of senators said not guilty, in their floor statements, they said he was guilty. He was guilty of perjury. He was guilty of obstruction of justice. But I don't think he should be removed. Therefore, that's why I voted not guilty. So it's a complete nonsense process in the Senate.
I think your questions are very good indeed. For the sake of discussion, further discussion over meals, etc., let me suggest that impeachment has been used more frequently in the last 60 years than before. That is, we've had Nixon and virtually Nixon impeached and Clinton impeached, and both early in their second terms after rather whopping victories in the election. So so that leads me to wonder why, and maybe it's that impeachment now, instead of being used as a tool of last resort, it's being used to overturn an election in some fashion. And that's unfortunate because it's another example of deliberation being replaced by war. That's a sharp tool.
The big difference, and it connects to Tara's really excellent point about political parties, because we can't really talk about our system without talking about political parties, but they're not quite there in strong form early on, is that Richard Nixon was brought down by a coalition from both parties.
That's right.
Moderate Republicans turned against him, and the news was delivered to him that he had no votes in the Senate, or next to no votes in the Senate, by Mr. Republican Barry Goldwater, who walked over and said, Mr. President, you have less than a dozen votes in the Senate as I count them. And in the Clinton impeachment affair, I think there was perhaps one Senate Democrat who voted to convict, no more than that. A few Republicans actually voted to acquit. One or two or three House Democrats who voted to impeach in the beginning. It was a very partisan alignment in the Clinton affair and not in the Nixon affair.
I would note that the Senate had a double standard in that there's no doubt that President Clinton did commit perjury. A year or two before that, the Senate impeached a federal judge for perjury, and a perjury which was also unrelated to official duties. But that's politics. Another question?
My question was on exactly the topic Professor Amar just touched on. You know, throughout our history, members of Congress, you know, typically showed an institutional interest in, you know, defending the powers and the role of their branch. And it seems like one of the reasons that the executive has been allowed to overreach and that Congress has abdicated its power is that in recent decades that's gone away. You know, at some point, members of Congress decided that short-term policy goals of their party or of themselves overrided the institutional interest. So, you know, whereas in the past, you know, when presidents abused their war powers, we had Congress stand up as an institution and pass the War Powers Act. When Nixon acted illegally, the Congress stood up as an institution, not just to their party, and, you know, in a united way dealt with him. Now you have, you know, the executive branch taking really clearly, you know, unauthorized actions, but because it supports the in policy of groups in Congress, they completely fail to do anything about it. They have no sense of the institutional interest of Congress. That's a political matter, and it'll only change if people demand that it changes. But assuming it doesn't change, how bad does this, can Congress ever reassert itself if that doesn't change as a political matter? If you have members of Congress not willing to exert their powers, is there anything else that can be done that's going to result in Congress reasserting itself? And if they don't, how bad does this get if we have not just the last 30 years of Congress abdicating its power, but 50 or 100? What is the end game there?
And let me bring up something about Congress I don't think is adequately understood. How much Congress, this is counterintuitive, how much Congress protects individual and minority rights. It doesn't make any sense. Congress votes by majority. How can it vote for individuals and minorities? Well, you could ask the same thing about the Supreme Court. It votes by majority, 6-3, 5-4. And then you have to look at the facts. And I think the facts show very, very strongly that from 1789 forward, the branch of government that protected individual rights, rights of blacks, the rights of women, the rights of children, the rights of religious liberty, the rights of Native Americans was Congress, much more than the other two branches. And when Congress did protect individual rights, such as passing the 1875 Act to provide for equal accommodations, blacks would public facilities, struck down by the Supreme Court 1883. We didn't get it until 1964. Women who wanted to practice law, they would go to courts, and the judges would say, you can't. I mean, it's absurd to think of women practicing law, but if you want that right, then go to the legislative branch. And they would go to the state legislature and get that right. And then the famous Meyer-Bradwell case, they go to the Supreme Court, 1883, and there's not any support on the court. In fact, one of the justices said there's a divine ordinance that says women are here to take care of husbands and children, and some women don't marry, but they're the exception. And shortly after that, a woman went to Congress, 1878, to practice before the U.S. Supreme Court, which had a rule that women can't practice here. 1878, an all-male Congress. You think she had any possible success? Her bill passed within 1 year. And it's amazing to watch Congress during those years to understand that they are the institution to protect individual and minority rights that are not protected in the courts. And it's only lately, Congress continues to do it with the Lilly Ledbetter statute after the Supreme Court gave her no success. So Congress has that capacity, and I think you have to educate the members of Congress that and lately with sex trafficking bill. That was passed by the House. The Senate didn't do anything. The House passed it again. A really good bipartisan bill that finally got through the Senate. So Congress has a really good record that I don't think is much appreciated.
That's, I think, very well said. It's why I tried to begin with the First Amendment and the rest of the Bill of Rights, which came from Congress, and the 14th Amendment, which came from Congress, just as a reminder to us all. But on the question about whether Congress is ever going to assert itself, of course, the founders are envisioning separation of powers of branches, and with the Congress ambition checking ambition and legislative power pushing back against executive or judicial power. And Tara reminds us, actually, we now have political parties in ways that weren't perhaps initially fully foreseen. The same, at least the kind of political parties, weren't quite foreseen by the founders. That means we have actually today, in effect, separation of parties and not powers. This is a phrase used very famously in a series of articles by Professors Darrell Levinson and Rick Pildes at NYU Law School. And here's what this means. When you have unified government, there may not be very much pushback by the legislature against the president if they are if House, Senate, President are controlled all by the same political party. So then they're going to, even though the framers might have imagined an ambition-checking ambition and institutional rivalry, partisan alignment blunts all of that. But the good news, perhaps one might call it good news, is we haven't had actually unified government for most of the modern era. We've had divided government. Every single president since Lyndon Johnson has faced an opposition, at least part of Congress, opposition Speaker of the House, for example, for some or all of his tenure in office except Jimmy Carter. And so what that does mean is, in an era of divided government and with hyperpolarization, where the most conservative Democrat in the legislature is to the left of the most liberal Republican, which is what you have today. You didn't have that in the 1960s and early 70s even. But now you do. Divided government actually reinvigorates a formal division between legislature and executive, and you get Benghazi all the time, and which is not actually formally in the enumerated powers, this power of oversight, but that's what you get with divided government.
To comment on that briefly, another complication of the party system with respect to the separation of powers is that even in the English Constitution, which was the model, at least in theory, from which the framers were operating, the executive had no political party. Even when the Crown could have asserted its prerogative powers under William and Mary and under Queen Anne, once the Hanoverians come in, the Crown retreats in its power, and Parliament is able to usurp the power of the executive. But even when the Crown could have asserted executive power, it did not do so in a partisan sense. Here in the United States, under the party system, we have an executive that by nature belongs to a political party. And so this complicates matters substantially, because of, one of the perils of congressional abdication of responsibility is that there is an abdication of power to the executive. And without the executive having to affirmatively usurp power, it can, in fact, do that at the expense of Congress. So what's the solution? Well, we can educate members of Congress as to their responsibilities. Another solution is to embrace the times when we have a president and a Congress who belong to different parties and hope that there are opportunities for compromise.
I totally agree with Professor Amar that ironically, the divided government is in some way the contemporary equivalent of the separation of powers and sort of checks and balances, and it's ironic. But the interesting thing is there's a critique of that, and the critique, which I don't agree with, is that creates dysfunctional government. And that phrase itself implies what government should be doing. It should be all together in a coordinated effort through the presidency and the administrative state. And somehow that has become not just the modern presidency, but an understanding of the modern Congress. And this attachment to political parties that Professor Amar has been mentioning is extremely important, because while there will be, say, attachment to parties, attachment to factions, attachment to movements that Madison might have anticipated, but not in the contemporary way, I think somehow he held out the possibility that an attachment to the institution to be called a member of Congress was something very, very important. And I've noticed over the last few years the extent to which members of Congress of both parties have been leaving to go to the administrative state. And I can say Obama, Biden, Clinton, Rubio, Cruz, and we can go on. What is the lure of the administrative state over against being a member of Congress? I was shocked to hear Governor Romney warn the Speaker of the House not to become the Speaker of the House, lest he diminish his future possibilities for becoming president.
The one great book on divided government is authored by someone who's right here in our midst, David Mayhew. The book is called Divided Government. I would love to see an updated version of that with new data on the recent era. I hope, David, you give us that at some point. But Divided Government is a very important book on this topic.
I would note from my own experience that there has been a very significant evolution within our two parties. I found when I was in the Senate, and that was 40 years ago, that because of my strong feeling about limiting the federal government to those areas of responsibility spelled out in the 10th Amendment, I found myself voting more often with Southern Democrats than I did with Northeastern Republicans. In any event, we have another question coming up.
Yeah, thank you, Judge. This is a real question, not a speech. When talking about the 17th Amendment and its ratification process concerning the direct election of senators, my understanding was that prior to that ratification, many states had internally passed legislation by which effectively the people in those states elected the senators. Am I wrong about, what was the story before the ratification?
You're absolutely right. That story is told actually in some detail in Chapter 11 of the America's Constitution, a biography book that I wrote in 2005. Here's how it worked. The process begins as early as 1858. They're called the Lincoln-Douglas debates, and you're all familiar with them. So why are Lincoln and Douglas debating, for the Senate position if actually there's not direct election of senators? Well, version 1.0 of this reform is each party before the state legislative election tells you whom it will nominate for U.S. Senate. The Dems say, if we win, we're going to send back Judge Stephen Douglas, Senator Stephen Douglas, and the Republicans meet before the November election, say, if we win the state house, we're going to send old honest Abe, and that turns that state legislative election into a quasi-referendum on the U.S. Senate. Now, that's only because there weren't that many other important local issues, and the Republicans actually get more votes statewide than Illinois, but not quite enough to actually win the state house, because there's gerrymandering, there's malapportionment, not all seats are up at stake, there are rounding errors and other things, but that's 1.0. Later on, here's what happens. In a bunch of states, we actually have one-party states in effect. In the South, they're solidly Democrat. In certain Midwestern states, solidly Republican. And when those parties hold primaries for their state Senate nominee, again, Lincoln-Douglas style, the primary is really the main event. The state legislature is just ratifying the primary contest, and that primary contest is a kind of direct election. And then, so now we have a whole bunch of states that in effect have direct election through one-party sort of control and primaries. That's 2.0, and 3.0 is called the Oregon Plan. Here's what the Oregon Plan is. Americans are very inventive. This is public opinion at work. On the ballot You can vote for the member of House of Representatives. You get to vote for governor of your state and state assemblyman and state senator. But there's also a beauty contest portion of the ballot. Whom do you prefer for U.S. Senate? It's officially non-binding, but you can say, I like Buckley, you know, I like Smith, and woe unto the politician from the other party who doesn't respect the people's formally non-binding beauty contest vote. That's 3.0. Next version. When you run for state legislature, 3 things appear on the ballot. Your name, R or D, you know, your party, and P or not P, whether you've pledged or not pledged to actually accept the beauty contest result. And again, woe unto you if you pledge to do so and don't, and woe unto you if you don't pledge, because people are going to say, well, you think you're smarter than us? And then there's still further adaptations of the so-called Oregon Plan, but by the time of the 17th Amendment, a considerable portion of states already in effect, have versions of direct election, which helps explain the puzzle that Gordon left us with. Why would 2/3 of the Senate ever change the rules by which the Senate is arranged? Because they love the rules that got them elected. Why would 3/4 of the state legislatures actually give up this? Because they really weren't exercising this power to begin with.
Yeah, Akhil mentioned Lincoln. I wanted to underscore one thing that Lincoln did that showed his respect for the Constitution, that when the Civil War started, he took all of his actions, habeas corpus and everything else, and then he called Congress back into session July 4th, 1861, and he did not, as presidents have been doing after World War II, to say, I have an emergency power, I have an inherent power, I've got Article II power. He did not say that. He told members of Congress what he did, and then he said, to his credit, I do not think anything I did went beyond the constitutional competency of Congress. He's saying flat out, I used Article I power, and the only way it could be made constitutional is for you to consider what I did and pass legislation retroactively supporting what I did. So that's a president, and he's rare, who understood the limits of his power.
A former congressman who called himself a Whig because they thought that Andy Jackson was acting too much like a king, so they named their party as the anti-kingly party. But Abraham Lincoln, with the spot resolutions as a congressperson, very much former congressperson believing in Congress, just like John Marshall is a former congressperson who believes in Congress. He's upholding congressional power. McCulloch, only once in his storied tenure on the court, 34 years, does he actually vote to invalidate an act of Congress. That's Marbury. Usually he's upholding acts of Congress, as are Joseph Story and other former congresspeople. You get your first office. There used to be, now we actually have a separation of careers in which judges, not so many judges are former senators today. They're former, and not so many justices are former senators. But in the old world, you often started in the first branch, and from there you went into the second or the third.
Okay, next question.
Yes, Roger Pilon with the Cato Institute. This discussion has been entirely too friendly. I'm going to try to spice it up a little bit. This is a question to Lou Fisher with respect to the war powers. As you know, Lou, we've debated this more than once. And it springs from something that Professor Lloyd said. I don't know whether he misspoke or misread when he spoke of the Article 1, Section 1, first sentence being all power herein granted shall be vested in a Congress. It actually reads all legislative power herein granted shall be vested in a Congress. And that leaves open the question, what are the unenumerated powers of the executive branch and the judicial branch? And of course, one of those is the power in foreign affairs. This morning, Politico says that reports that Congress wants nothing to do with passing an authorization for war. You have said that this is a post-World War II problem. Truth is, we have had upwards of 200 foreign uses of power, military power abroad, over our history, and only 5 declarations of war. Congress has the authority to authorize, or rather to declare war. It's not required to do so. The executive takes many actions of a warlike nature without congressional authority. Are you saying that all of those actions are unconstitutional, and that the executive has to go to Congress for every exercise of military force abroad?
Well, the frame is that at Philadelphia certainly recognized that the president could repel sudden attacks, so we've always had that kind of defensive
But they didn't write
power.
that.
Pardon?
They didn't write that.
No, but there was an understanding the difference between defensive and offensive. And Jefferson, when he took office, he brought ships into the Mediterranean, and there was military action against the Barbary pirates. And he came back in December of 1801, told Congress what he did, and he said, beyond the line of defense, I cannot go. And Congress passed 10 statutes authorizing both Jefferson and Madison to take military actions against the Barbary pirates. So there was that understanding always, and there are always presidents who chase bandits across the border and so forth. So no, you don't have to have congressional action on that. But it is true that on all the major offensive actions against other countries, presidents either came to Congress to get statutory authorities with the first war, the quasi-war, about 20 statutes clearly going to war, but it wasn't declared, or declaration of war. And the fact is, we have changed fundamentally from 1950 to the present time of presidents going to the Security Council or going to NATO allies for, quote, authority. To me, it's fundamentally unconstitutional. The reason I say that is that in 1945, when the Senate debated the UN Charter, everyone understood what had happened under Woodrow Wilson when he refused the Lodge Amendments, and everyone understood that Congress had to have the primary role. And when the Senate was debating the UN Charter, Truman was in Potsdam, and he cables a member, and it's put into congressional records, made public. I want Congress to know that if I ever use U.S. troops in a UN action, I will come to Congress first and get authority. Okay, that's just a presidential pledge. But then the UN Charter said that every nation state has to decide for itself what its constitutional processes are. That's in the UN Charter, constitutional processes. So Congress had to decide that, and the House and the Senate, certainly not just the Senate, the House and the Senate debated it, and they passed what is called the UN Participation Act of 1945, and that explains constitutionally how we use U.S. troops in a UN action. And Section 6 says that the President shall come to Congress and get authority. And 5 years later, Truman violated not only his personal pledge, but that statute. And I think all the times we have gone to Security Council or gone to NATO allies, as with Kosovo, we have been violating the Constitution. We've been violating the UN Participation Act. And I think any president who does that should be thrown out on his ear.
But since the question of my interpretation or reading or misquoting came up, I think the most one could say is that I was sloppy or saving time, because when I say Article 1, I meant the legislative power. So what you've done is to bring out what I had intended. All legislative power herein granted is the precise language. The main point to that is that the herein granted has been used by both sides, conservative and by liberals, to grant legislative power to the president. That, I think, is an important point. Seeing the herein granted as a separation of powers question, whereas what I tried to do is to say that the herein granted is really a federalism question, not a separation of powers question.
And with that clarification, I've been advised that this panel has completed its duties. Thank you very much for attending it.